difficulties, my lord. May I pray to list after my lord vacation?
Number 5 after vacation. Mr. Arbuzon.
My lord, similar prayer in respect of item number 18, my lord. I have taken consent from the other side, my lord, immediately after vacation, my lord. 18, my lord.
After vacation. The AHMR Chaudhary. You informed the other side?
Yes, my lord. Obliged, my lord.
One promotion.
Yes.
My lord, I think section 24 application. Hello, only my point is this, my lord, that learned charge ending is bypass. If you also see page 103 in order. Last
Yes.
4 lines first para. More importantly, respondent stated that income from all sources is per month from all sources. His next income tax return. Return has not been considered. Now, my lord, if the losses come to paragraph 12, page 105
This is for what?
for maintenance.
Being asked to pay how much?
16,000 maintenance, then 50,000 litigation expense and 3,000 repairs.
Per month.
My lord, this is if you also see, my lord, what I have said, page 67. That was totally, my lord, wrong, my lord. It was a joint property and this amount is to be distributed among the 5 persons. Among the 5 persons, my lord. That pharmacy is a joint, my lord. Total income is this much, page 67, my lord. You also see, which, my lord, the Tamil court has wrongly, my lord, in that is my income.
67.
67. my lord. Item number 3, last point number 3, monthly income. 64,858.
You have a pharmacy?
My lord, pharmacy, but that is to be joint pharmacy, my lord. That is the inherited property. My lord, your loss is approximately on average basis, which is shared between the 5 members of it. So it is not my sole income, my lord. My income is, my lord, it will be around 16,000.
So your bank statement?
Yes, my lord. Income tax return. At page 76, my lord. Other incomes also. Net profit declared is 70,000 per year, my lord. Then another income tax return is there. Here, my lord, it is 67,000 at page 78. The respondent having income, my lord, that I have to.
So you say if you pay the 16,000, what will remain to on you?
Yes, my lord. Yes, my lord. And I have annexed this certificates also, my lord. They are at page 70. I think. 5% legal. Yes, actually.
Then whenever she appears at Jorhat
But that I'm not. My lord, that's where the loss is at
and litigation expenses,
50,000, my lord.
nominal, so that you pay. Pay this 50,000 and plus you pay 4,000 now, monthly. Till the next date.
What?
Monthly 4,000. They have made it 60,000, 16,000, 4,000 monthly. And 50,000 you pay and whenever she appears, 3,000. Here, the other side. Heard Mr. G. N. Sahiwala, the learned senior. This is an application under Article 227. 18 for 2020, passed in Ms. A case number 24. Making it returnable. 2nd of August 2000. By way of registered. And within 3 days. In addition to that, the petitioner is also directed to effect service by way of dusty route through the registry of this court and file an affidavit. The G. N. Sahiwala, the learned senior counsel, drawing the attention of this court. The affidavit of assets and liabilities submitted by the petitioner before trial court. It's that the total income is earned by the by pharmacy is 64,008, which is to divided amongst 5 members of the family. He therefore submits that amount to which the petitioner's share in respect to income 1/5 of the amount of rupees 6,858. Learned senior counsel further submits that the learned trial court, however, directed 10,000 per month, which is more than what the petitioner get from the business of the from pharmacy business. The learned senior counsel, however, has no objection in respect to 1,000 as litigation and cost as directed by the learned. There's also payment of 3,000 as and when the respondent appears at court. I've also perused the affidavit of assets which have been filed, and from the affidavit of assets, apparent that what mentioned that 64,808 shared amongst 5 members of the family. Such circumstances, there is a prima facie case requiring intervention of the court. Under such circumstances, is the impugned judgment and dated 18/4/2000 subject to number 1, payment of rupees 4,000 per month. The respondent for the upkeep of herself and her minor son. Payment of the litigation expenses of rupees 50,000, as well as also payment of rupees 3,000 as and when the respondent is before the Jorhat court. It, however, made clear that if there is any medical expenses to be incurred on account of child, the petitioner has to bear the same.
Go to
So this is a landlord-tenant dispute, my lord. It reaches up to High Court, my lord. High Court has upheld the decree, my lord. Then, my lord, execution case has been filed. The execution case, my lord, the person, my lord, the original, my lord, person died. He, my lord, has given, my lord, the power of attorney, he also died. But there was a, my lord, other document which, for which, my lord, we have filed a substitution.
You're challenging which order?
My lord, this is the order, my lord, at page 31, my lord.
What is this order for?
So this is because, my lord, mainly because it's that the land is a matlab, government land, well, we have no right. That is the main purpose. The lawsuit see, my lord, at page,
You are the decree holder.
I'm the decree.
Then what happened?
Decree was put into execution. They filed several petitions. They approached the High Court again. In this way, it is going on. Now, my lord, my execution case has been actually made infructuous, saying that this suit land is a government land. So I have no right.
Where?
But the page 36, my lord. In last two paragraphs, the decretal land is a government khas land as admitted by the petitioners. Therefore, the pertinent question arises as to whether right can be transferred by any party for operation of government khas land. Honorable Guwahati High Court in so and so held that encroaches over the government land does not have legal right on this land. And in Mukut Goi, same my lord thing has been said. Therefore, the persons who are
Mr. Sahiwala, yesterday me and Justice Chaudhary has delivered a judgment on Rule 18.
I've heard, my lord, I have not gone to it, my lord. Yes.
There we have made a very categorical thing. Encroacher having no right does not arise. If it is so, then obviously, why is the land policy there? Encroacher, if he has some right, he may have a right even for the purpose of getting a settlement, the wasteland or government khas land. And that is even the policy of the government. So understand that they will have a bona fide. In fact, earlier, after the judgment on Radha Kanun, it has been assumed that an encroacher has no right.
Absolutely. Yes, my lord. Radhakan-
That has been assumed, although Radha Kanun did not take note of Rule 18.2. He explained what is the bona fide right of claim in
Bona
bond.
fide claim of right and other things.
No, why it has been all along, it has been all along. In fact, with due respect to the other judge, division, they have all along taken it as a bona fide claim. Bona fide claim is different from bona fide claim of right in bonds. It's something like a prima facie legal right. You have a prima facie legal right, you cannot exercise 18. Which is completely different from a bona fide claim. Bona fide claim means you may have a claim. Thing like the unauthorized premises where you have a bona fide dispute. Bona fide dispute is different from a bona fide claim of right in bond. Anyways, I think we'll issue notice, nothing to. It's making it return. Heard Mr. G. N. Sahiwala, the learned senior counsel by Mr. S. Mrs. Of the petitioner. So, this is an application filed under Article 227. 115.
But that is correct, my lord. I permitted my lord to.
Yeah, 115, not 227. Can it be 227? If your matter has already been gone, then it cannot be done.
It can be converted, my lord. I can, your lordship will permit, my lord. Oh, my lord, it's pending. I'm sorry. My lord, it is pending, my lord. That is right. Pending.
But why should we interfere? What has happened thereafter on 1/4?
My lord, that I have not taken.
Because why I'm saying it, the court said that we, as the petitioner, that is none of the parties have come before the court. You see, now perusal of the record that the actual decree holder are not present. So therefore, the court fixes for necessary orders after recording all these things. Then what happened on
My lord,
1/4?
if the filed an application here, my lord, there is another aspect of what matter. If your lordship relinquishment did it.
Maybe, but it is fixed for necessary order on 1/4. Why should we interfere now at this stage with this matter?
That is the, my lord, I don't, my lord, I should take it.
Ian Sahiwala, the learned senior counsel, submits that he will take instructions as to what has transpired pursuant to on 1/4/2024 in the execution proceedings being titled execution case 15. The matter immediately after the elections.
A.
Yes, Mr. Sekia, what are you challenging?
My lord, I have challenged the order dated 9/4/2024, my lord.
Where is it?
That is 84, my lord.
Huh?
84.
84.
Yes, my lord. Yeah, my lord. Earlier, my lord, on 31st of May 2022, an ex parte order was passed, my lord. Because of
Yes, why should we interfere?
my lord, the petitioners are original petitioners are the legal heir of original petitioner number 2, my lord. The
Defendant, they are the defendants.
Yes, my lord. The disputed land, my lord, is ancestral property of the petitioners, my lord. Now, my lord, if this order, my lord, sustained, then, my lord, the petitioner will not be able to defend their cases, my lord.
Why are you not if you are not serious out there, why should we exercise 227?
My lord, that is done by my counsel, my lord.
I can't help it.
Yes, my lord, but
Go,
my
go
lord,
and file an application, proper application before the court and file it out. If they don't consider it is a different thing, nothing to do with this court.
yes,
This
my
court
lord,
is not going to interfere with this.
my lord, I do agree, my lord, that
Mr.
order is not.
Withdraw. This matter can't be done. Mr. M. Soikia, the learned counsel appearing on behalf of the petitioner submits that the petitioner herein, who are the defendants in the suit, would be well advised to file an application before the learned trial court seeking an order to vacate the suit, the ex parte, the order, and pursue it more diligently. And as such, he submits that he would not like to press the instant petition. Taking into account the above, the instant petition. However, liberty is given to the petitioner to file an application before the learned trial court. That is the court of the Civil Judge Junior Division, Kamrup at Amingaon, in title suit number 112/2018, file an application for vacating of the ex parte order, and it is observed that in the circumstance such application is filed, the learned trial court shall duly consider the same and dispose of the same on merits. I think this is the best order you can give.
A pleasure.
Order 4 for admission.
In the last occasion, my name. I will argue the case. He is in
What?
traffic exam, my lordship.
Huh?
So can the matter may be passed over for time being? He is
Why?
Mr. P.K. Sharma stuck in traffic exam in Silpupuri.
This is a matter where the stay was vacated.
Yes,
Yeah.
yes, my lord. And
After
after a lot
the
of
learned counsel
efforts,
has
we have
appeared
made
and that
clear.
he along with Mr. R. Ali Ayah do not represent the petitioners and therefore the name should not be shown in the, I have heard Ms. B. Counsel, she submits case by the petitioner today, therefore she prays for time. Yes, what is your case?
I will argue the case. That's why matter may be time being for
Who is Mr. P.K. Sharma?
our senior.
We get hold of ask these people to get hold of a garland to invite him? What? Why is he not before his court?
No, my lordship is stuck in traffic exam. That's why, my lord.
That's it. The matter will listed after vacations.
My lord, it was meant to be disposed of the last occasion itself. The time may be given, it may be taken up at 2.
Absolutely no. Why should I? What is the matter about?
The matter is stayed in the, not stayed, but it has not resumed in the trial court because
Let us not,
they do not know. which
madam,
stage
let
to-
us not beat around the bush. What is the matter about? What is
it
the
was a
challenge
shock.
here?
It was a shock and
What is the challenge here? What is the impugned order?
it was about doing away with the DWs and the PWs.
Huh?
Doing away with the DWs and the PWs were cancelled and the matter was
Considering the
fixed for
matter that
argument.
the prayer of the prayer has been not allowed and the petitioner has prayed for the same relief prayed in month. This order, how they have to cross-examine the plaintiff. Show me the order of 33, 2022. 33, today is the date fixed. Petitioner is unrepresented till Iman. I have heard the learned considering the absence of. This court is inclined to presume that the petitioner is not willing to pursue the.
It's on page number 35, my lord.
Restore Iman to the original state within 7 days from the Iman. Prayers hence dismissal. Thus the. What order is that? You set aside the order of 33.
Of 30, on 30th, the order was passed that the defendant, the petitioner defendant is unrepresented till 4 o'clock. And then respondent plaintiff is represented and I have heard the counsel for the respondent plaintiff and then considering the absence of the petitioner defendant, and non-submission.
What is this petition 353?
Then there was a adjournment petition.
Yes. Case is fixed for cross-examination on Iman. The conducting advocate for the defendant was present to some emergency work and necessary steps was taken. Take the petition Iman 6D4D. Unintentional default. To allow the defendant side to cross-examination of the plaintiff witnesses and to adduce DW. Now, this petition was dismissed for default at page 28.
As at page 36 and at page 28 of the petition, yes.
So that was dismissed for default.
That was dismissed
Now, thereafter, he filed another application for,
for the same prayer.
with what prayer?
Praying that, the petitioner, the PW he may be allowed to cross-examine the PW.
Then, and therefore it has been rejected, so this is before
At the
us.
submission, yes. Both the DWs and the PWs have been done away with.
We allow the petition. You see, these are small petty
Exactly.
matters, madam.
Very petty.
If we
matter.
go into this only delays the proceedings.
Yes,
We allow them, fix a date, and there shall be no further adjournments. That's all.
I may be allowed to face up.
What?
Only my prayer is that
they may be allowed and the matter may be disposed of.
Yeah, no, you will be allowed to cross-examine
Yes, your lordship.
on a date which will be fixed by the trial court, and you shall not be entitled to any adjournment.
Oblige, your lordship.
Yes, then the matter may be disposed.
No. Unless you say these type of matters should not be. Chalo. The instant application is heard, Miss
P. Bhuya.
Bhuya, the learned counsel appearing on behalf of the petitioner, also appearing on behalf of the respondents. An application filed challenging the order dated 15/3/2023, whereby the learned court of the Munsif number 1 Sipsagar had rejected the application filed for permitting the petitioner, who are the defendants in the suit, to cross-examine the plaintiff witness and also to educe the evidence of the educe defendant evidence, witness, as well as also educe defendant evidence. First, this court have perused the records in the instant proceedings, including the petition which was filed being petition number 353/2021, the order which was passed on 30/3/2022, as well as the petition which was filed being petition number 574/2022, and the order and the impugned order which has been passed. First, it appears from the materials on record that it was on the fault of the council which had led to the defendant being deprived of cross-examination of the plaintiff witness, as well as also filing of the defendant witness, as well as educing defendant evidence. So taking into account that a substantive right of defense is being taken away, had been affected of the defendant, and the procedural laws are always subservient to the interest of justice. This court interferes with the orders dated 30/3/2022 as well as 15/3/2023 passed by the learned trial court in Mize case numbers
5-3 and
in Mize case number 32/2021 and Mize case number 59/2022 respectively. This court further permits the defendant to cross-examine the plaintiff witnesses and also to educe evidence. This court, however, makes it very clear that the defendant have been, as a special circumstances, have been given a further chance to cross-examine the plaintiff witness, and as such would not be entitled to seek for any adjournment pursuant to the date so fixed by the learned trial court. This court, therefore, taking into account that when is the next date fixed?
we do not have that information.
5th of July. 5th.
It has been informed to the court by the learned counsels appearing on behalf of both the parties that the next date is fixed on
5th of July.
5th of July. On the said date, the learned trial court shall fix a date for cross-examination of the plaintiff witnesses. And on that date, so it is made clear that on that day, said date, so fixed, the defendant shall not be entitled to cross any further adjournments on the adjournments. With the above, the instant petition stands disposed.
Highly alright.
For 6,
Yes, Mr. Elgebora. And Mr. Alkebuya comes
Lordship,
running from there without a caveat. Why?
My lord, during the pendency of this appeal,
Eh?
appellant number 4 has already died.
Sir?
Appellant.
So you mean to
24
say, as appellant number 4 has died, this court can't dismiss the appeal today?
No.
Then what? What is the intention behind saying that the appellant number 4 had died?
I have informed the original court.
Obviously, I can't pass an order against the dead person. I can't dismiss the petition, isn't it?
Forward.
So I have to give you time, isn't it?
One thing, my lord,
Mr.
despite
L.K. Bora.
she has died, but other legal errors of the This is has already been in a record.
Oh. Yes. Basanti Burma.
Yes, Basmati died.
No, 1, 2, 3 are the legal heirs of different number or
No, one is a husband.
legal heirs.
Yes, he is not legal heirs. Husband is not, may not be legal heirs as plus one legal heirs, but 2 and 3 are the sons.
Why husband is not?
Plus one legal heirs.
That's one, no. What about section 16 of the Hindu Succession Act?
Second class legal heirs.
What second class? He
Last one.
becomes first class.
Last one.
Being the husband, he becomes.
Wife is.
It is not there in the schedule,
Yes,
but in view of section 16,
Yes.
he becomes a class 1.
Last one.
Then,
no, S.
anyways, tell me, what is your case? You want to do it, means seriously.
My case is that the appellant, the respondent, as plaintiff filed a suit before the number 1 at Nolbury for declaration and permanent injunction and confirmation provision in respect of the suit line. Suit line is 4 kotha 10 races against the then appellant defendant, and suit was decreed.
Mr. L.K. Bora, where are your substantial questions of
My
law?
substantial question that suit line has not been identified.
Where?
Aye.
In the
Uh,
memo of appeal.
Yes, ground number.
No, no, no.
Separately, I have not filed substantial question of law.
You have the CPC with you?
Yes,
Read the CPC, section 103. Read.
yes.
There I don't have much matters. 100 bracket 3. What did he say?
Yes. Second,
Yes. Yes.
appeal for appellator.
Ah.
Even otherwise expressly provided in the body of the code or by any other law.
No, no. Section 100 bracket 3. Yes.
In an appeal under this section, the memorandum appeal shall precisely state the substantial question of law involved in the appeal.
Not done properly. You can't do it like this. Mr. L.K. Bora, the learned counsel submits that he would like, he seeks for an accommodation so that he can bring on record the draft substantial questions of law which the appellant proposes. List the matter immediately after vacations.
Till then, they have given assurance that they will not proceed with the execution proceeding.
Absolutely no. This court first has to exercise the jurisdiction under 100. It is a different matter that there is some courts which issues notice. Notice is not conceived of. They come only at the stage of section 100 bracket 5. Not before that. 7. Yes, the person expert in education matters now in the second appeal. Yes, tell me.
My lord, after notice to the my lord respondent, my lord plaintiff, this matter is before the law.
What?
Dr. Kindly look page 66. This appeal was already, my lord, admitted on to substantial question of law, page 66. But while this matter was heard, my lord, another, my lord, substantial question of law was surfaced, my lord, that
Where is the substantial question of law?
page 66, my lord,
No, no, there is an order being passed on 17/11/2023
yes,
to make out any substance that may be involved in a firstly, the appellant defendant takes a ground in the written statement as so and so.
my lord, I have prepared, my lord.
The second ground, the urge is third ground, urge is demand. The statement is clear enough that it is an averment in the plaint that they are ready to execute. The ground is in reference to the proposition area wherein it is shown there is a condition precedent. From the above contentions area, no substance is discernible. So there is no substantial question of law discernible.
Provided my lord to find, prepare my lord further substantial
Then?
I have subject to correction, or I have prepared substantial question of law. Actually, my lord, earlier occasion, my lord, this substantial question of law already formulated was not placed, my lord. But during the
Whether there is no averments in the plaint that they are ready and willing?
no, my lord.
Great. Let's see. Where is the plaint?
Lord, page 44, my lord.
44. Yes, there is a statement is there. Issuing a notice that I will be there with the money in the sub-registrar's office. You come and execute, take the money. That is willing, ready and willing.
My lord, they were also did not.
Anyways, today, should I dismiss the last day?
My lord, there are some other, my lord, genuine, my lord, facts and law is also involved, my lord.
Facts and law, facts I am not going to see. Law.
my lord,
None of your substantial questions of law are in any manner a substantial question of law.
another-
One, and secondly, it is more of a complicated questions of law rather than a substantial questions of law.
My lord, another, my lord,
How is it relevant, these the aspects of the matter? There was an agreement
earlier another agreement was there.
with,
My lord, when, my lord, this, their father, my lord, purchased the land from this seller, my lord, there was a condition, precedent, that within 4 years I will return you back the land. In the meantime, my lord, they, return also this land, my lord.
then there is another agreement.
That, my lord, they showed, my lord, we are disputing regarding that, my lord.
Did you challenge that agreement?
Criminal case is also filed, my lord.
No, criminal. That is why Education Department Council, I'm saying, criminal case cannot set aside the agreement. You can't set aside an agreement which is there by filing a criminal case. A person may go to jail.
Yes.
That is a different aspect of the matter from this.
Therefore, Finding,
Then,
finding is also there, my lord.
finding of what?
Lordship can able of page 20, my lord.
What is the
That is,
finding?
in the new judgment, my lord.
What
That, my
is
lord,
it?
there is a agranoma is also there. My lord, in the meantime, it is also registered, my lord, land is, my lord, delivered, it is also there, my lord. But wrong finding is that, my lord, it is held that, my lord, that was, my lord, subsequent. But actually it is, my lord, earlier.
Which one?
This, my lord, ikranoma, my lord, purchased land with the condition to return within 4 years, my lord. But learned appellate court, my lord, held this is subsequent to the, my lord, agreement.
And what does the trial court hold?
Trial court held that, my lord, that this is not, my lord, they fail to prove that they are ready and willing, etc. My lord, the findings are there, my lord. But
So the trial court dismissed the suit
dismiss the suit,
and the appellate court allowed it.
allowed,
The case of reversal.
reversal. Therefore, my lord,
So you say that there were two agreements.
yes, my lord.
What was the first agreement?
First agreement, when purchased the land, my lord, that, my lord, one ekranoma given that I will return you back within 4 years if you pay the money, my lord. Then, my lord, in the meantime, my lord, there, my lord, filed one case, my lord. That, my lord, there was a, my lord, the agreement for sale. That is disputed. That is
The agreement for sale on which the suit was filed on the basis of an agreement for sale?
Yep.
What is that date of the agreement for sale?
This is subsequent to the this Ekranama, my lord.
So, is there any concept of a novation of a contract? The earlier contract which ceases to exist in view of the new contract?
Yes, my lord, therefore, my lord, I am saying, my lord. Because, my lord, earlier, once, my lord, this land was, my lord, already with the agreement of the, my lord, seller.
Let us see your written statement. What do you see?
And I think, please to, my lord, see the findings. Okay, my lord. Our written statement on page
By the
52,
father, namely friend.
52, my lord. And after, next submit, my lord, another fact. That admittedly, my lord, notice was only issued to one person. Very narrow campus, my lord, still was allowed, my lord, holding that it is subsequent, but it is earlier.
No. This agreement for sales happens subsequently.
Subsequent.
Then why you are not making? That is the agreement for sale which has been put in the suit.
Yes, my lord.
Then why you are saying all this? Earlier Ekranama, forget about that. We are not concerned. There is a novation of a contract and we have not challenged that agreement. You say that it is fraudulent. You file a criminal case. That has no relevance out here. We are not concerned with that. Sometimes if I am sitting out there in the criminal court, you may very well say, but nothing to do with the civil matter. Civil matter, you have to either challenge that sale deed, the agreement for sale, if it is a fraudulent document. You have not challenged it. Making all this statement doesn't, but it is an admit. Your case is, look here, at the time there were certain disputes, and after those disputes, certain blank signatures were
Yes,
taken.
my lord.
And on the basis of that, they made the agreement for sale and which is now being put for specific performance.
Yes.
That is your
You-
case.
you see that.
But you have not challenged that agreement for sale.
They disputed, my lord, and my lordship kindly will look findings of the appellate court, lordship, page 20, my lord. Page 20, paragraph 6, my lord.
20.
Paragraph 16, my lord.
Huh?
Paragraph 16, my lord, page 20,
15.
paragraph 16, my lord.
Whether the plaintiff is entitled to a decree for
My
remand.
lord, in the, my lord, my memo of appeal, my lord, page 2020, my lord, judgment of the appellate court, my lord, paragraph 16 onward.
Paragraph 15.
16, my lord.
Yeah. The defendant side also proved various documents, including the number, so and so. Ratio number, what appears from the present case is the defendant and it seems longer. Let us see. What is wrong with that?
Because, my lord, here, my lord, our, my lord, say, and my lord, Ekranama,
You have not challenged that Bainama.
my lord, this is, my lord,
We dismiss.
after vacation, my lord.
No. No more time. I have given you so many opportunities
No,
today.
my lord, I
Take
understand.
time.
Just one time,
Hmm.
but It
No,
depends on your
no,
lordship.
no. You thought that it is very
No.
easy to get a second appeal
I
admitted
but
here.
upon your lordship, my lord.
What?
Your lordship, my lord, they are very much aware all these civil matters, my lord. But after vacation, my lord,
For what?
they are also notice issued, they have also not come.
Who?
Other, my lord, please keep.
Others not necessary. Others are not necessary. They are not to be
Thank you, madam.
consulted at
Thank you,
all.
after vacation.
Take this. The Borgoya, this is not substantial question of law. This is more of a complicated question of law. Mr. A.M. Borgoya, the learned counsel submits that he seeks admits that he needs some more accommodation to prepare a fresh set of potential questions of law which are substantially involved with the instant people. Into account above is the matter of the some vacations.
Keep tablet.
Yes, Mr. Jain.
I am facing same problem as well Lilabora.
Huh?
Lilabora, same problem I am facing. There is no separate substantial question of law.
Not here.
My
The
lord, after vacation,
Mr. R.K. Jain, the learned counsel, submits that he may be given some accommodation to bring on record the draft questions of law which the appellant proposes to be substantial questions of law. List the matter after summer vacations.
fine, orders. Is your lordship?
You got 9-1. Why it has come?
Lordship, there is a delay of 172 days.
How much?
1,872 days. 1,872 days. Your lordship.
Then
And the respondents have filed their affidavit in opposition, your lordship. So there should be a hearing in this case. I am appearing as a proxy counsel, your lordship.
proxy
Yes, the engaged counsel.
none appears on behalf of the petitioner on call, appellant on call. List the matter after the summer vacations.
Obliged, lordship.
The record shows that the LCR has been, SCR has been received. As entered appearing, the LCR has been received by the section. LCR anyway. Huh? Uh-huh. LCR received will as our LCR received matter for admission hearing. What is the admission hearing? Appellant may raise substantial questions of. The registry shall give an update as to whether the LCR has been received, taking into account the contradictory office notes, notings dated 23/11/2022 and 27/2/2023. It is also observed that in the circumstance the LCR has not been received, the registry shall take appropriate steps. None appears on behalf of the parties. Matter will be adjourned after vacations.
After vacation. Lord.
How much? 772.
Absolutely due to my mistake. But my mistake, brief was misplaced.
25,000 cost on you.
Pardon?
25,000 cost on you.
Very poor people, carpenter, Lord.
No, you. Not on him. You. I've done it similarly. If it is your mistake, own it.
Cumbersome. for-
And because of it is a carpenter, you may have not given importance.
You taken after me. I have to
But
get-
provided you have a case. That day what happened, I will impose a cost of 25,000 upon the lawyer because he made the mistake. Thereafter, after he paid that amount, then I see there is no substantial question of law to be framed. If you don't have a case, then matter becomes useless. You pay 25,000 and at the end of the, yes, I will condone it if it is your mistake. You own it, yes, but pay 25,000. That
Taken
was a
after
junior lawyer, huh?
I have to catch a flight by 2.
What?
I have to catch a flight by 2 here. I have to.
List the matter after some occasions.
Like,
And appears list the matter after some. 14 service is complete and LCI has been received. Service complete, LCI has been received. This is the matter for hearing in the usual course, liberty given for filing applications for early hearing.
Well, after August, it may be people read it.
Absolutely no. I am giving you the liberty. You file an application for early hearing.
Yes, Mr. Lord. Okay, 1 to 6 have entered appearance,
What about 7 to 11?
their name may be strike out. Their name may be strike out.
The G. Bhardwaj, the learned counsel appearing on behalf of the appellant submits that the respondent number 7, names of respondent number 7 to 11 may be struck off, taking into account that they did not participate in the trial proceedings as well as also in the first appellate proceedings. Taking into account the above, the names of the respondent number 7 to 11 is struck off. So it is, however, noticed that the service upon the other respondents are duly complete and the LCR has been received.
They're not received.
LCR has not been received. Complete. Good stuff. However, the LCR has not been received. Under such circumstances, the registry shall forthwith take appropriate steps for calling for requisitioning of the LCR, and thereupon, after receipt of the LCR, list the matter for hearing in the usual course. Liberty, however, is given to the file appropriate application for early hearing. If
The item number 6
what?
is also same.
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 Same order. বেলেগ হ'ব কিন্তু দেই। এটাতে নহয়, বেলেগ হ'ব।
Your lordship,
Yes, why haven't you taken steps?
some time may be granted to take steps, lordship.
Cost?
Lordship, due to some inadvertent mistake, lordship, I think the.
Mistake of the lawyer?
Lordship,
Mistake of the lawyer? Mistake of the lawyer, 5,000.
last chance may be given, lordship.
Counsel appearing on behalf of the applicant submits that he is going to take steps during the course of the day. Take it today.
Yes, lordship.
Gusto. List the matter after completion of steps. Service upon the sole respondent.
Right.
19,
What correction?
The Lordship on order dated 9/5/2024 in page number 10, your Lordship. The dark number was wrongly written as 376. It should be 356, your Lordship.
What?
All page number 10, your Lordship, in judgment.
Ah.
In the last second line, your Lordship.
Page
Page number 10.
10. What is there?
Last second line, your Lordship. Firas Patta number 376.
Page number 10,
Order dated 9/5/2024, your Lordship.
order dated,
9/5/2024.
the judgment,
Yes, your Lordship.
then where?
Last second line. Your Lordship.
Its judgment starts writing from page 12. Where is it? Page 10.
Your main
Paragraph which one?
paragraph number 5, your Lordship.
What is this?
Last second line.
Ah.
That this Kiras Patta number 376, it should be 356, your Lordship. 356.
How does it make a, you are the defendant.
Yes, in title suit we are the defendant.
How does it make a difference?
Your Lordship, in earlier all the places.
I've only dismissed the appeal.
No, your Lordship.
Allowed?
Yes. Already in several places it was already corrected, but in only this.
Exhibit K.
Yes, your Lordship.
Anywhere else written?
Yes, your Lordship.
Where?
In same page, paragraph number 5, last fourth line, Kiras Patta number 356. Above second line.
This is an application for correction of a typographical error which occurred in mentioning the number of Khiraj Patta, which was exhibited as Exhibit K. The counsel appearing on behalf of the applicant submits that the correct number of Khiraj Patta is 356 and not 376. Record to Asani?
Already flag marked, your Lordship, yellow flag mark. Exhibit.
Beyond to 90. Section 376 ne? K Kongji. This court have also perused the records wherein Exhibit K is in respect of Khiraj Patta number 356. Accordingly, the mention in paragraph number 5 of the judgment, mention made in paragraph number 5 of the judgment and order dated 9/5/2024 passed in the accompanying second appeal in reference to the Khiraj Patta exhibited as Exhibit K shall be understood to be 356 and not 376. The instant order shall be a part of the judgment and decree dated 3/9/5/2024 passed in the accompanying second appeal. I disposed. Finished. Hearing. Yes, who wants to do a hearing on the last day? Huh?
Not me, man. Probably.
This is your lordship will hear. Your lordship wanted to hear.
What is this? Matrimonial?
This is a matrimonial appeal, my lord. This can be summed up, my lord.
Yes. Am I taking up this bench? I'm not taking up this bench. This matter should have gone to the other bench. Because I don't take first appeals. Yes, what is the ground?
Now, my lord, what had happened, my lord, I can sum it up, my lord. There was an application filed by them for restitution of conjugal rights, my lord.
Ah,
Now, my lord, for reasons, my lord, that that application was decreed in their favor, my lord,
Mm.
against the wife. I am the wife. Now, my lord, immediately thereafter, they filed a divorce suit. The divorce suit was also decreed in their favor. Now I come before this court under section 28 of the Hindu Marriage Act as an appeal matter. My limited ground for this appeal is that, my lord, the decree which was passed in the divorce suit, my lord, the divorce application was premature. Because, my lord, the law says that if the application for restitution of conjugal right fails, then after 1 year they can file, and they file it within 2 months. I need not go into the merits of, there are other issues, my lord, on that very ground.
now what has happened to the decree for restitution?
My lord, the restitution decree, the order was that we had not turned up, and therefore it was decreed in their favor, and they have,
But that decree still is operating.
Hello?
Decree still is operating.
operating, my lord, because once the divorce decree,
There was a divorce,
it is gone.
but the decree is still operating.
No, my lord, because once a divorce is, because that is prior to divorce. Now, once divorce, there is no question of restitution of conjugal rights.
Whatever may be,
Yes.
you say if you go into the question of premature,
Yes.
then we have to look into it, whether the decree is operating.
My lord, a decree of restitution of conjugal right, my lord, I have not researched on that, my lord, but yes, my lord, if I, because that would now yell nothing, my lord.
No,
in a-
no, because otherwise it makes no sense. 2 months, okay. At that point of time, the court should have dismissed, provided you have raised the issue. But otherwise, if a passage of 1 year have now passed by, and appeal being a continuation of the state proceedings,
But then, my lord, the divorce petition which was filed is against the mandate of the act, my lord, because there is specific provision that divorce petition can be granted only after 1 year of restitution. And there was a, my lord, there was a philosophy behind that, is that in case some gestation period is given, my lord, now for,
understood. But then also the period of 2 months, 1 year is over now, as of now.
that regard, my lord, I'll have to the legal consequence of that, my lord. I'm not prepared on that point, honestly speaking, my lord, because I,
One has to, you see, in a divorce proceedings or matrimonial proceedings, that you can't be so strict or rigid on what it is. You may have it in other proceedings, but not in this. Yes, you may also like to go for a resolution or whatever may be. These are things, a perspective is completely different in a matrimonial proceedings than any other proceeding.
my lord, what it followed from your lordship is, my lord, is precisely, my lord, the point I am urging, because the husband is hellbound to leave the wife. I am not willing to go out from the matrimonial home.
Then
my
why
lord.
you are, why, that is why, did you ever express in your written statement that you are still going to comply with the restitution decree?
We were against the, we are against the decree of divorce, my lord, which
Restitution.
But the-
Restitution is for what?
conjugal rights, my lord.
Absolutely. You don't want to come.
No, my lord.
No, yes.
I was,
No, You
My-
can't come up with all these things.
No, my lord, I was not making submissions on merit of the case because my lord,
I'm
if I-
not on merit or this is on the basis of this is the aspect. Did you ever say that look here? This is a restitution application decree because if that is the basic ground on which it is being given, there are many grounds one can give. The decree may also be on the basis of cruelty. I've not looked into it. Decree may be also on the basis of cruelty. The
Desertion
decree may be on the basis that there has been 1 year past post a judgment of the decree of the restitution of conjugal rights, then also nothing happened and as such go for a decree for divorce. That is another aspect. But did you ever say during the trial, in the divorce proceeding, look here, I'm willing to abide by the decree of restitution.
my lord, in my, then your lordship will kindly see the written statement at page 43, which I have
What do you say?
filed before the.
Let's see, let us see the plain first.
Hello.
What is the ground?
Ground, they have filed it,
Cruelty also.
under section 13(1).
No, it's a cruelty
That's
also.
cruelty ground.
No.
But divorce is given on the ground of desertion.
Where have you seen?
My lord will kindly come to divorce application at page 33 plain.
Okay, we make it on cruelty. Convert it into cruelty. Maintenance.
Now, my lord, because the.
We are in appellate decree, first appeal. First appeal, one can very well do it. We convert it into cruelty. Go for mutual.
But there has to be some pleading for, because the cruelty pleading did not yield, the judge was not satisfied with the cruelty pleading and therefore divorce on the ground of desertion.
Did the court say that cruelty, we are not satisfied?
But the divorce was granted. My lord will kindly see page number 27.
Yes. Issue number 2. Refusal on the part of any of the spouses for cohabitation itself amounts to cruelty of the other spouse and as such done. So,
My lord,
rightly
for
said.
more than 5.5
Oh.
years, this, my lord, in that event, my lord, I'll
We
have to go
dismiss
to-
it.
No, my lord, of that event, I'll have to go to the
We
evidence.
dismiss it. Enough. Too much. These matters should be finished.
Well, then, my lord, because my lord, I was under the impression because they have clearly violated that mandate of the law. Now, if your lordship is willing to condone that part of
Forget
violation.
about that. We are not, let us not go into the issue number 1. Let's go in the issue number 2.
So, my lord, I'm talking of the premature application.
Therefore, that is issue number 1.
My lord.
That is issue number 1 which have been framed. On issue number 2, it has been held to be a cruelty. Page 26.
My lord, this is, for that, my lord, we'll have to see whether the finding is based on the evidence on record or not.
Evidence, it is there. You are not come in spite of a decree for restitution.
My lord, those were all behind my back, my lord. My lord, that is why, my lord, if your lordship wants to hear it on merit, my lord, we'll have to.
You heard it. Do you need anything more?
Yes,
I think by 12 o'clock we can finish up with the judgment. Done and dusted. You can
Because-
get the signed order at 2 o'clock.
Then in that,
Sealed and packed. Not over.
in that event, my lord, since your lordship has also expressed that whether a hearing would be done on the last day or not, my lord.
That I asked you.
So my lord, so let us have a day immediately on reopening. I'll address on merit. Keep it part heard, my lord. I'll be.
Why should I? This is not actually my bench, but you wanted to do it on a off day. Means on a day where I am not taking up these type of matters. Therefore, you see, this
I-
matter was taken up by Justice Saikia. Justice Saikya was taking up, he's taking up the other civil bench where appeals are being heard, first appeals. These are first appeals. I take the second appeals and there is the second civil bench is a different. No, it is there, very much apparent from your, from the roster.
Should have verified.
Therefore, it should have been before Justice Medhi. Medhi is taking in the first civil bench. But anyways, we have heard, we finish it off now.
Will not be so cruel on the last day of,
Huh?
cruel on the wife on the last day of vacation, my lord.
2023. You're married?
Lordship, because there is an order from the court not to get during pendency of the appeal.
What is your age?
I am now 56.
Oh, you are not going to marry, so no problem. You are working?
No, I have no work because I am jobless also. My mother is a cancer patient and I have nobody to look after her. So I am only with him to have to look after him.
And why you are asking for divorce?
Your Lordship, because I certainly,
These are things which will raise.
Your Lordship will see all together everywhere they have participated in the proceedings, all the proceedings. And lastly, they did not appear on the ground, the illness and all this. And now they have come with this appeal. Then if Your Lordship go through entire thing, will come to it is fraudulently they have come here. The order passed by the court below was rightly passed. And Your Lordship, now what they have done, even now they have filed one petition for MRA case for before domestic violence and section 125 maintenance now when the pendency of this appeal. Before that, they did nothing. So now all for frivolous cases they are filing now. Just they don't want
You
that.
file an application which stay all these things.
482 can also be.
No, that is only I have received
No,
notice
no,
only
you
now.
file it here.
Your
When the
Lordship,
divorce is going on, what is all these other applications?
that's true.
A
But I
divorce
my
decree
client,
has already been passed. What is this domestic violence business? Only stay is to that effect that you can't marry.
Absolutely.
if that says,
Otherwise, the divorce is the
or
decree.
Your Lordship may vacate that order, then they let it continue. This appeal. That order may be.
I don't get, my lord, I'm not being able to follow, my lord, what the consequence, because the submission is that the mother is a cancer patient, nobody to look after. The wife is the best person.
Your
So in
Lordship,
the garb of,
Therefore, tried to get a decree for the restitution, but you have only construed to be a restitution of
No, my lord.
conjugal rights, not a
the
restitution
facts are something
to
else.
the marital life. Yes.
Facts are something else, my lord. We'll address it on the day of hearing, my lord. The facts are something else.
What is there to, yeah, matter over?
My lord, will not, because my lord, I have also not gone deep into the evidence, my lord, because we'll have to see the
Evidence is not like that.
evidence, because my lord,
There are many judgments to that effect that if they eat, you don't come, prohibit. That is the main reason. Yes, it is a different thing for judicial desertion may not be a ground in view of the judicial decree within 2 months. No quarrel. But after having known that there is a decree for judicial for restitution and there is a decree being passed, you then not prohibiting would amount to a cruelty. Amount over. Decree passed.
so my lord, because I had never tried to, my lord, come out of the matrimonial home. I
Then
was
go.
all along willing
Why
to.
didn't you? Therefore, I asked you, what happened to the decree for the restitution? You don't want to comply with that. You don't want to comply and file all these DV cases.
Tomorrow morning I'll go, man. I'll instruct
After
my client
7
to go
years.
tomorrow morning.
After 7 years, Your Lordship.
Now-
After tomorrow, you are. Why didn't you instruct your client all along? And have only when I have just put this question, you are now saying.
So my lord, because my lord, they have instituted the case even at a place, because this lady
Is the
stays
matter
in.
after vacation.
Lordship, it will be listed on.
I can't fix a date. I'm not taking up this roster next time. What is this 18? 18 is over.
869.
18 is not here. Somebody has taken in his own. Yes. What interim order? Why was 18 adjourned?
I have some difficulty, my lord.
So you have no difficulty till now.
I was thinking matter will be taken in second half, my lord. That is,
Why?
it will take.
18 file to Asani. Good. Matter over, fine. Anyway, nothing is going to happen.
Objection in the injunction.
You have got an injunction. Itu 18 or itu query early interim order passed earlier shall continue till the next date. Fix a date. Earlier date was what? When do you want it? No, we have to fix a date. There cannot be a interim order unless we make it absolute. Huh?
Last week of August, madam. Last week of August.
Item number 18 listed on end of August 2024. Interim order passed earlier in the injunction proceedings shall continue till the next date. So, Mr. Ambitious,
Whatever date.
you
my lord.
survived.
Happy vacation. my lord.
Okay.